When you picture the law, you probably picture this timeless pursuit of justice, right?
Yeah, absolutely. You imagine a courtroom, a judge weighing right and wrong.
Exactly. The scales of justice balancing human morality. It feels deeply human, like this monumental moral undertaking.
Right, a noble tradition.
But what if I told you that over the last 150 years or so, the law was actually secretly hollowed out and replaced by, well, a giant unfeeling vending machine?
A vending machine. That's quite the image.
Right. You put your facts in the slot, pull a lever, and a legally binding judgment just drops out the bottom, completely detached from human morality.
It's a stark contrast to the scales of justice, for sure.
It really is. And welcome to your custom-tailored deep dive. Our mission today is to unpack a remarkably dense but totally eye-opening article by Young Kang. It's titled The Modernity Crisis of the Common Law.
It's a fascinating read, extremely thorough.
Very thorough. And the goal here is to give you, the listener, a profound aha moment about the very foundation of the legal system you live under. Because, it quietly shifted right beneath your feet.
It really did. And to understand this massive transformation, we have to kind of rewind a bit. Back to the mid-19th century, to a time when becoming a lawyer looked, well, nothing like it does today.
Okay, so paint a picture for us. What did it look like?
So the daily reality of the American legal market in the 1840s and 50s was entirely localized. If you wanted to practice law back then, you didn't, take the LSAT and go to a fancy university.
Show student loans.
No, you did an apprenticeship. You would go to a local law office, sweep the floors, copy documents by hand.
Wait, literally sweep the
Like,
floors.
yeah, you were the office grunt.
Yeah.
And you would literally shadow a practicing lawyer for years. You absorbed the law not as a set of abstract theories, but as a deeply practical, localized craft.
Like learning a trade.
Exactly. You learned how the people in your specific county handled, say, property disputes or broken contracts.
I mean, that makes sense for a smaller agrarian society, but I have to imagine that model completely breaks down once the railroad boom hits, right? And the Industrial Revolution kicks into high gear.
Oh, absolutely. It broke down fast.
Because suddenly you have companies signing contracts that cross like 5 different state lines.
Right. The localized apprenticeship model simply could not scale to meet the demands of a unified national market. An apprentice who spent 5 years learning the quirky property customs of rural Massachusetts was suddenly,
Totally useless.
right, totally useless when dealing with a complex interstate railway contract spanning all the way to Ohio.
That's a huge problem.
It was. The United States was rapidly expanding its federalist framework, and it desperately needed a legal profession that could operate fluidly across that entire national market. And Harvard, they recognized this bottleneck.
So they stepped in.
They did. They introduced a totally new system, the university-based law school. They created systematic national curricula, so a student could go to one place, grasp general legal frameworks, and then adapt them to literally any state in the country.
So the physical location of legal education moves from the dusty local office to the pristine university classroom.
Exactly.
But the article points out that this institutional shift, it mirrored a much deeper structural dismantling of how the common law actually functioned.
Nice.
Because to build the modern vending machine, they first had to demolish something called the writ system. Okay, let's unpack this. What exactly is a writ?
Think of a writ like a highly specific historical permission slip from the king or the court.
A permission slip. Okay.
Right. Under the old common law, the golden rule was no remedy without a writ. If your neighbor stole your cow, there was a specific historically established stolen cow writ you had to file.
It had to be that exact one.
Yes. The procedure and the facts of your injury were permanently glued together. If someone wronged you in a novel way and there wasn't a historical permission slip that matched your exact problem,
You couldn't sue.
you often just couldn't sue. You were out of luck.
Oh, man. That sounds incredibly frustrating. I'm trying to imagine living under that system. It feels like learning to cook by standing next to a master chef who absolutely refuses to write down a recipe.
That's a great way to put it.
Like, it's hands-on, it's bounded by centuries of tradition, and if the chef doesn't have a specific historical dish for your exact craving, you just don't get to eat.
You go hungry.
Right. So when the mid-19th century rolls around and they abolish this writ system in favor of a new philosophy, which was where there is a right, there is a remedy. I mean, that sounds like a massive victory.
It does sound like a win.
They cut the red tape.
Yeah.
If you were injured, you get a day in court,
Oh.
regardless of the historical permission slips. So wasn't getting rid of that actually a good thing?
Well, what's fascinating here is that removing that red tape unleashed a hidden consequence, one that permanently altered the trajectory of the law.
Okay, what was the catch?
The writ system, for all of its rigid, frustrating bureaucracy, served a vital function. It protected experiential order.
Experiential order.
Right. Because facts and procedures were so tightly fused, judges were forced to stay grounded in specific historical scenarios. They couldn't just invent sweeping legal theories out of nowhere.
Uh-huh.
When the writ system was dissolved, substantive law was completely severed from those procedural chains.
Meaning a judge looking at a stolen cow case no longer has to confine their thinking to just cows. They
Exactly.
can suddenly look at stolen cows, stolen wagons, stolen pocket watches, and start making up grand abstract theories about the fundamental nature of property rights.
Spot on. They began cherry-picking precedents from entirely unrelated fields of human experience to invent abstract principles. And because of that, the law began to float away from the historical soil where it originally grew.
It lost its anchor.
It did. Without the physical constraints of the writ system, the common law was on the verge of fracturing into total chaos. A judge in New York could invent one abstract theory of property, while a judge in Pennsylvania invented a totally contradictory one based on a different set of cherry-picked cases.
So nobody knows what the rules actually are anymore.
Right. The law desperately needed a unifying mechanism to make sense of this new freedom.
Here's where it gets really interesting. Because stepping into that chaos is an ambitious academic at Harvard named Christopher Columbus Langdell.
Yes,
In the 1870s, as the dean of Harvard Law School, Langdell looks at this messy, floating web of cherry-picked precedents and decides that the law isn't a historical craft at all,
He declares that the law is a pure science.
like chemistry or physics.
Exactly like that. Langdell completely severed legal education from the practicing profession. He stopped the tradition of bringing in seasoned judges and trial lawyers to teach students.
Just fire the actual practitioners.
Basically. Instead, he created a brand new species of professional, purely academic legal scholar. And these scholars didn't view themselves as craftsmen at all. They viewed themselves as scientists working in a laboratory.
And the laboratory was the law library.
Precisely. The library was the factory. They believed they could use deductive logic to extract perfect, eternal legal principles from past cases, completely bypassing natural law, theology, or, the messy realities of the street.
Which brings us to his famous case method. Like, if you've ever watched a movie about law school, like Legally Blonde, you've seen the case method.
Oh, yeah. The intense questioning.
Right, students reading old appellate decisions and getting grilled by a professor. And on the surface, that sounds like it's deeply grounded in reality because you were reading about real human conflicts.
It sounds empirical.
But the article points out a massive irony in how Langdell actually operated. He would invent a grand abstract theory first, right?
Yes, theory first.
And then he would meticulously comb through thousands of cases just to find the 4 or 5 that perfectly supported his hypothesis.
It's textbook confirmation bias.
Seriously. And if a precedent contradicted his beautiful theory, he just tossed it out. He dismissed it as an anomaly.
Because the pursuit of 19th century scientism demanded complete formal unity. Langdellianism forced the infinite, messy diversity of human life into a pristine, theoretical box.
Which doesn't really work.
No, it doesn't. And this is precisely where your vending machine metaphor becomes literal. Under Langdell's scientific vision, the judge is no longer a wise elder weighing the moral nuances of a community conflict.
They're just pushing buttons.
The judge is reduced to a machine operator. You input the sterile facts of a case. The judge processes those facts through Langdell's logically coherent abstract system, and a mathematically precise judgment drops out.
But when you trim human life to fit a pristine theory, the cost is extreme rigidity. You can only force the gritty, real world into a theoretical box for so long before the box shatters. And by the time we hit the late 19th and early 20th centuries, society is transforming at lightning speed.
You have massive corporate monopolies forming.
Right, labor strikes, urban poverty, and the vending machine is spitting out judgments that might make perfect logical sense on paper, but they are actively destroying society in practice.
The human cost was immense.
That triggers a massive rebellion.
It does. The pushback began with American historical jurists, people like Cooley, Tiedemann, and Hammond. They argued that law must be a product of social development, not an eternal geometric system.
It has to breathe.
Exactly. But the rebellion exploded into a full-scale war in the 20th century with the legal realists. They looked at the vending machine and pointed out that the emperor had no clothes.
A central figure here is Herman Oliphant, who delivers this explosive lecture in 1926. It's called Return to Stare Decisis.
A hugely important moment.
And just for you listening, stare decisis is the legal principle of following precedent, basically standing by things that have been decided. But Oliphant argued that the vending machine had completely corrupted this concept.
Oliphant accurately diagnosed the mutation. Originally, stare decisis was a method of cautious, incremental accumulation of experience.
Taking it one step at a time.
Right. A judge looks at how a specific conflict was resolved 50 years ago and takes a tiny step forward based on those concrete facts. But Oliphant pointed out that under the new scientific model, judges weren't looking at the facts of past cases anymore.
What were they looking at?
They were practicing stare dictus, standing by the words.
They were just quoting the philosophical tangents that previous judges wrote in their opinions.
Exactly.
Treating those abstract musings as if they were unbreakable laws of physics, completely ignoring the actual human beings involved in the original dispute.
It was all about the words, not the reality. And Carl Llewellyn, another giant of the realist movement, took the critique even further.
What did he say?
Llewellyn argued that law is never actually designed by professors sitting quietly in their studies. True law is generated in the chaotic arena of actual litigation.
Like in the courtroom during a fight.
Exactly. As everyday people and corporations drag their interests into court, the friction of that conflict forces judges to continually auto-balance and reinterpret the rules.
Just dynamic.
The law is a living social mechanism, not a static mathematical formula.
Wait, hold on. I need to stop you there because this feels like a dangerous pivot.
How so?
So what does this all mean? If the realists are exposing abstract principles as a joke and arguing that law is just a reflection of whatever society and litigants want in the current moment, aren't judges just making it up?
That's a valid fear.
If it's all just social practice and competing interests, what stops a judge from acting like a politician in robes? How is that any safer than the unfeeling vending machine?
Llewellyn recognized that exact danger, and he constructed a safeguard. He advocated for a temporary methodological distinction between what ought to be and what is in legal research.
Okay, so separating facts from morals.
Temporarily, yes. He wasn't abandoning morality. He was arguing that before we can debate what the law should do, we have to brutally and honestly observe what the law is actually doing in society.
We have to look at reality first.
Exactly. The realists were not trying to burn down the common law tradition. They were attempting a desperate self-repair from within.
Fighting a two-front war, basically.
Right. They fought the rigid formalism of the Langdellian vending machine on one flank, while simultaneously holding off radical progressives who wanted to use the law for sweeping, instantaneous social engineering. They wanted gradual, reality-based reform.
And just to be clear, we're not endorsing any political stance here, just reporting Young Kang's analysis of the history.
Of course, it's just tracing the historical arguments.
Right, so the realists successfully point out that judges are just humans making decisions based on society. But realizing that opens a terrifying new door.
It does.
Because if the law isn't an eternal science, and it's not a deeply rooted historical tradition, what stops it from just devolving into raw political power?
That is the big question.
And that exact fear is what philosopher Eric Vogelin noticed. Vogelin looked at this inside baseball debate between law professors and realized it was actually a symptom of a massive civilization-level crisis.
Vogelin shifts our entire framework. He diagnosed the crisis of the common law as a direct reflection of the crisis of modern order.
That sounds intense.
It is. For centuries, human beings understood order as participation in a transcendent truth, something larger than ourselves that we humbly strive toward. But in modernity, humanity abandoned that posture.
We thought we knew better.
We did. We started treating order as an object. We became convinced we could technically construct a perfect society purely through our own ideas and systems. Vogelin labeled this the impulse toward ideationalization.
Ideationalization, that's quite a mouthful.
It is, but the article breaks that impulse down into 3 clear characteristics.
Let's go through them.
Yeah.
First is system first.
Yes. Treating the messy diversity of human life as an annoyance that just needs to be smoothed over by a system.
And second is deduction first. Distilling a massive, complex history into a few sterile principles.
Exactly.
And third, self-sufficient knowledge. The arrogance that the library contains everything you need to govern society.
You don't need history or the outside world.
It makes me think of drawing a map to help navigate a territory. But over time, the map becomes so hyper-detailed, so complex and abstract, that people stop looking at the actual terrain.
They get obsessed with the drawing.
Right, they start trying to literally live on the map instead of in the real world.
Taking that map analogy further, if we connect this to the bigger picture, when society naturally evolves and someone points out a massive new river that isn't on the map, the Langdellian judge doesn't update the parchment.
What do?
They look at the map, look at the river, and declare that the river legally does not exist.
Wow.
That is what Vogelin means when he says the law loses its patience and humility toward reality.
Because it's supposed to be an experiential continuity, right?
Exactly. A judge is not supposed to claim they possess the ultimate final truth. They're supposed to walk cautiously, guided by the constraints of past experience. But the ideational system traps scholars and judges in a loop of self-confirmation.
And Vogelin identifies a very specific, dangerous weapon that emerges from this.
Yes, he does.
When we shifted from the old writ system to the idea of where there is a right, there is a remedy, we fundamentally changed how society argues.
Everything became about rights.
Exactly. Because remedies are now based on these abstract concepts of rights. Those rights become what Vogelin calls weapons of legitimacy,
They're ideological tools.
used to constantly attack and redefine the entire legal system. I mean, if you can continually invent or stretch the definition of a right, you can force the courts to endlessly reshape society.
Yeah.
It makes the law inherently unstable.
Which is precisely why Vogelin warns that the realist movement, despite its accurate diagnosis, is not the cure.
Because it falls into the same trap.
In a way, realism effectively shatters the illusion of the vending machine, but it steps right into another modern pitfall. If you reduce the law strictly to calculable social facts and competing power interests, completely divorcing it from any dimension of transcendent truth,
You get nihilism.
you inevitably arrive at value nihilism. The law loses the artificial stability of Langdell's concepts, but it also abandons the guiding light of transcendent order. It just becomes an arena for whoever has the most leverage.
A pure power struggle.
Right. For Vogelin, the only way forward is returning to an understanding of order as truth in process. The law must move carefully through history, never claiming absolute perfection, but always remaining open to a higher transcendent justice.
So Vogelin focuses intensely on the loss of historical experience and humility. But the article introduces another philosophical heavyweight, Leo Strauss, who approaches the crisis from a completely different angle.
Yes. While Vogelin mourned the loss of experience, Strauss mourned the loss of a moral compass.
Strauss grounds his entire critique in the decline of natural law. Right?
He does. If you examine the traditional common law, even though it was highly procedural and built on custom, it rested on a foundational assumption. The law must strive to be in harmony with reason, justice, and goodness.
It had to aim for the good.
Precedents were respected not simply because they were old, but because they represented a multi-generational historical exploration of what is just.
So under the old system, the law wasn't just a command from a sovereign or a mathematical formula. It was an institutionalized societal pursuit of justice.
Langdell's scientific revolution murdered that normative assumption. Langdell took the fundamental driving question of the courtroom, which was, what is justice, and replaced it with an entirely mechanical question.
Which was, is the system coherent?
Exactly. On the surface, asking if a system is coherent looks like methodological neutrality. It feels safe and objective.
Like math.
Right. But in substance, it hollows out the core of the law, creating a massive normative vacuum. The authority of the legal system relocates from a defensible pursuit of goodness into mere conceptual geometry.
It transforms from a moral calculation into a purely logical calculation.
Yes.
And Strauss points out how this totally warps our modern understanding of rights. In the traditional framework, rights were always embedded within a thick web of civic duties and community purposes.
You couldn't separate the right from the duty?
But when the vending machine takes over, remedies become exclusively rights-based, completely detached from duty or historical context. The courts get sucked into this overwhelming momentum of proliferating endless claims
They turn into sheer tools for constant social engineering.
and permanent political warfare. Again, just unpacking the article's perspective here, not taking sides.
Absolutely. But leaving the legal system profoundly vulnerable.
Right, because when a major, morally complex public controversy inevitably arises at the courthouse steps, the modern law is directionless.
Because it has explicitly abandoned the capacity to rationally discuss the good, it has no natural law standards to critique systemic injustice.
It has nothing to stand on.
But simultaneously, it cannot establish any real legitimacy just by coldly describing sociological facts. It becomes a hostage to whatever political faction or corporate interest exerts the most power.
Well, let me challenge Strauss's conclusion here.
Go for it.
Because when he advocates for recovering a normative standard and returning to natural law, what does that actually mean for you, the listener?
This raises an important question.
Are we supposed to regress to medieval theological dogmatism? Because telling a diverse, secular, modern society that our legal system needs to be anchored in pre-modern divine revelation sounds not just impossible, but highly dangerous to apply today.
A vital distinction needs to be made here. Strauss is absolutely not demanding a regression to pre-modern theocracy or religious dogmatism.
Okay, for you.
He is advocating for the revival of a classical philosophical attitude toward human existence.
How does that look in practice, though?
It is the foundational conviction that justice is a real phenomenon that can be rationally discussed, debated, and discerned by human beings using their reason.
Not just faith.
Right. It is a total rejection of the modern cynical posture that justice is merely a subjective emotional preference or a completely relative social construct.
Oh, I see.
If a society abandons the belief that justice can be rationally pursued, then the law ceases to be an architecture of order. It devolves into a soulless technique of governance, a mere instrument for those empowered to manipulate the populace.
Wow. To synthesize this incredible journey we've been on today, the law that governs your life is not just a static list of rules you memorize for a bar exam.
Far from it.
It is a living, breathing practice suspended in a deeply precarious tension. On one side, you have the ghost of Langdell, who tried to force the messy reality of human conflict into a pristine, abstract science.
The vending machine.
A vending machine of deductive logic that ignores reality. And on the other side, you have the realists, who correctly smash the vending machine, but risk reducing the law to a cynical game of social facts and raw power.
Both extremes fail us.
But if we look through the penetrating lenses of Vogelin and Strauss, we see that the true spirit of the common law is neither of those extremes. The true spirit is a humble, continuous, experiential pursuit of justice.
Grounded in history, but reaching for truth.
Exactly. It is a tradition that slowly, cautiously steps forward to find what is right.
It serves as a necessary reminder that the legal system is a human institution striving to participate in truth. It is not merely a machine to be engineered or a weapon to be wielded.
Beautifully said. And that brings us to a final thought we want to leave you with, something to mull over long after this deep dive ends.
It's a good one.
The next time you are scrolling through the news and you see a controversial Supreme Court decision or, a massive society-shifting lawsuit dominating the headlines, pause and ask yourself a question.
Look past the noise.
Are the highly paid lawyers and judges in this case merely arguing over who has the more logically coherent system? Are they just wielding abstract rights as weapons of legitimacy to reshape society in their image? Or, underneath all the technical jargon and procedural maneuvering, are they still capable of arguing over what is actually just?
That is the ultimate question.
Has the unfeeling vending machine completely taken over? Or is the messy, historical, deeply human pursuit of justice still alive somewhere inside the machine?
I guess we'll have to wait and see.
We really will.
Yeah.
Thank you so much for joining us on this deep dive. Keep questioning the structures around you, and we'll see you next time.